This hearing is in the matter of case numbers CFI 51, 2017, before His Excellency Justice Shamlan and Sawalehi. The claimants are represented by Clyde and Co, and the lead counsel is Mr. Tom Montague Smith, QC. And the defendant is represented by L.L.C and Company, and the lead counsel is Mr. Robert Reed, KC. Thank you very much.
Thank you. Hello, Mr. Robert, Mr. Tom. I hope all of you is fine. I went through the. I received half an hour ago the list of agreed issue, and the timetable. Personally, I don't have that much to comment, except the length of the hearing. When I saw the agreed timetable, I was a little bit not sure why we only have 2 witnesses every day on the second week. So if you can address me on this, that this is the only things I have so far, but I will leave the floor for you if you want to address me on something else.
Thank you very much, Your Excellency. So yes, well, as you've heard, we've got Mr. Rupert Reed appearing for the defendant, and also Mr. Killen, who is online. I will also at trial have a junior myself who's not online today, which is Edward Knight. So I just thought I'd introduce the team, as we will be spending a little bit of time together in fairly short order. Your Excellency, as you've seen, that there was a bit of disagreement originally, but overnight we've managed to conclude as between the parties agreement as to how we should go forward. So what I was planning to do was to explain just a little bit about the case. I'm not going to tell you too much background, tell you a little bit, take you through the draft order that you've seen, and then come on to, if you want to have any observations about the list of issues, and then deal with the timetable, probably last, unless you'd like me to do it in a different order.
No, that's great. Yeah.
Thank you very much. So you will have seen the submissions, and hopefully had a sense of what this case is about. We've got a trial that starts on the 18th of May, and as you've seen and noted, we're listed for 7 days. And at its core, the case is. Sorry, I've got a little bit of feedback, and I don't know whether or not there's anyone. Right, maybe not. Thank you, Rupert. I think that's what happened. So at its core, the case is about a contract that was signed, and I use that word, in January 2015, and then a few months later, in May 2015, the defendant wrote to say that it was cancelled. And my case is that the defendant had no right to do that. It was a binding contract, and by cancelling it, they deprived of us of a flow of profits which would have been earned from the performance of the contract. And the contract was for the provision of administration services for insurance policyholders. And the defendant says a number of things, but in essence says that the claimant doesn't exist as a legal entity, and secondly, that the contract never came into existence. And you will have seen there'll be quite a lot of legal argument on the first issue about UA law, and in the DIFC way, we will not be presenting you with expert witnesses on UA law, so we'll be making submissions on those issues. And just so you understand it, effectively, the defendant's position is that this arises out of the way in which the ownership of the shares of the claimant are structured, and the foreign ownership rules that arise out of that. I'm not going to get into that in great detail today, but just flag it up. There'll be a fair bit of submission in relation to that. And then the sort of second part of the case is about the contract itself. And what my learned friend says is that there are a number of reasons why the contract wasn't binding. He says that there are some conditions precedent to it becoming binding, and in particular there was to be a transfer of some of the shares in the claimant, and also the claimant had to get some licenses to provide these services. And we say, well, that this was an unconditional contract. My learned friend also says that in effect it could be cancelled before a certain particular date. So there's going to be some factual evidence which goes to what was agreed. There's a written contract, but I think what is being partly said is that agreement emerged out of things that were said, and there's going to be some legal submission about the consequences of all of that. And in addition, you will hear evidence in relation to quantum, and that will really be looking at my claim for effectively mostly loss of profits, arising out of what we say would have happened if the contract had gone forward. In relation to that, there's a prior question of what is the standard of assessment. My learned friend says, well, under UAE law, the standard is that we have to show that the profits that we lost were certain to occur. I say, no, we're in the DIFC court, and it's the DIFC standard, which is just the normal balance of probabilities. So there'll be a little bit of legal submission in relation to that, and then there's going to be a fair bit of evidence about whether or not this project would have been profitable for the claimant, and if so, how much profit was foregone. There are a number of other issues, and I won't go into it much more detail than that. If you like, we can look at them in the agreed list of issues, but that's really the shape of it. And so,
is it the governing law here is a UAE law?
The governing law of the contract is UAE law, but then there's an issue about how you go about quantifying losses. And I mean, we'll argue it out, but we will say that in the DIFC court, the assessment of damages is effectively procedural, and that there's quite a lot of law about that. And there's been a recent case in the DIFC about that as well. So we say the question of what kind of loss is recoverable is probably a question of UAE law, but how you assess it is going to be a question of DIFC law. And so we don't have to show that things are certain to occur in order to recover loss in your court. But my learned friend, sorry, go on.
So I guess expert in UAE law will be there. I mean, you're going to provide an expert.
No, we don't have any experts on UAE law. The way it's going to work is that we are going to be making submissions to you about UAE law. So that the central issues on UAE law, it seems to me, are going to be firstly this issue of the validity of the claimant. And that's my learned friend's argument that because of the way in which the shareholding was structured, the claimant is a void entity. And so he will be making much of the running on that, I suspect, and we have some points in response to it. But the parties have decided that will simply be done by submission. So as Your Excellency will know, it's really up to case management question as to how those sorts of issues are addressed, and the case management of this case has proceeded on that basis. There will be expert evidence, but that largely goes to the quantum questions. Largely, there might be some issues as to licensing in there as well. But essentially, there are going to be three lay witnesses, 2 from the claimant, 1 from the defendant, and then each party has 2 expert witnesses that you will need to hear from, 1 each on the insurance industry, if I can put it like that, and 1 each in accounting. And there are, just so you understand, there are effectively 2 substantial parts to the quantum claim. One part of it is the claimant's claim about what profits it would have made purely in relation to this agreement. That is, it would have earned commission and fees in relation to this agreement and the services it was due to provide under this agreement. The second part of it relates to my client's case that if the agreement had gone ahead, it would have amounted to the creation of effectively a key partnership in the jurisdiction, which could have been used to build its business more rapidly and more effectively. And so you've got expert evidence which deals with both aspects of that part of that claim. And the experts have been meeting and trying to narrow the issues. And I mean, my learned friend might characterize it slightly differently, but the way I sort of broadly summarize it is that the accounting experts have probably narrowed the real accounting issues more significantly, perhaps, than the insurance industry experts have, albeit there are still quite a lot of differences between the parties. So that's the sort of broad shape of the case. What we've therefore done is sought to agree some directions subject to your approval to trial. And so what I was going to do is just take you very quickly through what is quite a short draft order, if you have that, Your Excellency. And the first issue is of how we are going to be heard. Now, clearly, most of the hearings in the DIFC court have been remote since the lockdown following the COVID-19 crisis. I think both parties would prefer to have this hearing in person if you are willing and able to do that. I had misunderstood and put it into my written note for this hearing that had been agreed by the court, but I've subsequently been told, I think there was an email that went to the defendant's solicitors but didn't come to my solicitors, and we'd missed it. And we'd been rather reading the tea leaves a little bit through changes in meeting arrangements. But as I understand it, there's nothing agreed as yet from the court's side. And so the question remains as to whether or not we'll be in person or whether we'll be doing this through videos. And I don't know whether your Excellency has any observations as to that.
Well, for myself, I'm happy to do it in person, unless the DIFC court registry have different, a reason for not having in-person hearing. As far as I understand, of course, there is a encouragement to do it online dispute, but if the party, both of them, they want it in person, I don't think any reason why the court couldn't accommodate that.
Yes.
And
could I just jump into, if we could have the main courtroom too, that would be extremely valuable, because I anticipate there will be a degree of interest and there will be persons on either side, both sides, who will want to attend. So I know sometimes there are issues with, if there are two hearings or two trials, that one proceeds in the library and the other proceeds in the courtroom. And we would obviously have a strong preference that it should be in the courtroom if the trial is in person.
Well, now it either will be in the courtroom or in the meeting room for the DRA, in the DRA premises. If you are familiar with that, another premises we have on the third floor, if I'm not mistaken. But probably it might be an issue with the TV or the equipment in the courtroom. I'm not sure if it have some kind of maintenance, or this is the feedback I get from the court last time. So, but we need to double check with that. Yeah.
I mean, I think it's obviously more efficient to have short hearings by video, but I just I think the view of both parties is that where you have a relatively long, for the DIFC, relatively long hearing, 7 days, and you have live witnesses, it can be helpful for the judge to be able to see everybody in person. You get more from a live courtroom than you can be communicated through screens. But we'll perhaps leave it then with Your Excellency and take it up with the registry as to precisely what the arrangements will be. But you have our suggestions anyway.
So the witness, most of the witness in UAE, or some of them has to be travel from overseas?
I think some of them have to travel. Yes.
Yeah, and both counsel already booked that timetable to be in Dubai, or?
Yes, I mean, I think from my side, speaking for myself, I would be in Dubai one way or another, I suspect. So I did a lengthy trial, 3-week trial in the DIFC court remotely, and I spent the time in Dubai in any event. Just logistically, it's easier.
Yeah, Robert, Mr. Robert.
I think the same is likely to be true of us, given the time difference. It would make sense for the council team to be in Dubai anyway. And there would be strong advantages, as Melanie Friend says, in terms of being in court, not least moving witnesses through documents quickly, and likewise the experts. And in terms of your lordship's observations of the witness, obviously that's improved. So we would be keen to that the matter be the trial proceed in person in the DIFC quorum, if possible.
So you need the registry to confirm that as soon as possible to make all those arrangements for traveling.
Yes, and to the extent that Your Excellency has influence, we would urge you to bring it to bear.
Sometimes it's even outside my power if it has come to the technology and IT and the so we'll see. Yeah. But I think both of you don't mind to have it even in the meeting room in the upstairs in the another premises. You've been there in the DRA meeting room, yeah.
Not for a long hearing, but I've certainly done hearings in the DRA. I mean, I think it's second best. It's much preferable to be in the courtroom, but I think it's better than online. So yes, thank you.
Okay.
Very good. Thank you.
Yeah.
The next exciting topic for pre-trial directions is the issue of bundles, which has exercised the parties a little bit. Part of the problem is that the system for bundling has changed now from case lines to this new system, which we're all trying to get on top of. And I think there are a few technical challenges that are presented by that, which we've been discussing. And the proposals which are now agreed between the parties are those that you can see in paragraph 2 of the draft order. As I understand it, we already have complete from the defendant's side paragraph 2.1. So the first step was to be that the defendant was going to provide comments on the bundle index, and I believe that that has already happened. So now my solicitors can get on and prepare the bundle for uploading as soon as possible. Which they will do. That, as I say, is a fairly involved task, which they're going to achieve as soon as they possibly can, but by the 18th of April. And then the cross-referencing will occur. And it's only once the documents are uploaded that we can cross-reference, because it's only at that stage that we get the pagination out of the bundling. And that will then go in 2 stages. Firstly, both parties are going to cross-reference their own documents. It'll largely be the witness statements, but there may be some aspects of the expert reports that require that. So the defendant's going to provide their cross-reference copies of documents as soon as practicable and by the 1st of May. And then the claimant will upload all of the cross-referenced documentation. So there's a full and completely cross-referenced bundle uploaded by the 4th of May. If it can be done sooner than that, it will be done sooner than that. And the advocates on both sides obviously have an interest in that happening as fast as reasonably possible. But that is what we felt we could commit to. So hopefully that suits Your Excellency. One question that arises from that is what format Your Excellency would like bundles in. It may be that you're happy to work entirely from the electronic bundles. It may be that you would prefer to have some or all of the bundle in hard copy. So if Your Excellency has a preference now, we'd be very grateful to hear it. If you want to tell us later, we can receive that in another way.
No, electronic file is better for me. Yeah, definitely.
Very good. All right. Well, if at any stage Your Excellency decides that you would like to have, for example, the witness statements in hard copy, then please do just ask the registry to communicate that to us, and we will make sure that we prepare that as soon as we can. All right, that is that. Then in relation to written openings, you'll see the next part of the draft order. I'm hoping that we will be well short of 40 pages, but we felt that it would be a good idea to put a page limit on written openings so that it doesn't get longer than that. And so that is what we have agreed. Again, if it can be done shorter, it will be done shorter. We won't be filling pages just for the sake of it. And then we have now agreed that we will exchange those written openings by the 5th of May. So that is, well, just shy of 2 weeks before trial. No, just slightly less than 2 weeks before trial. So that will give everybody a clear view of what is being said, so that we can make the trial as efficient as possible. And then there'll be a chronology and agreed reading list by the 12th of May. Hopefully it won't take that long, but we give ourselves that time in case there's a bit of back and forth. And safer cost, that's pretty much it on the draft order. Before I move on to the timetable, there is one other thing that is outstanding, which is transcription, the choice of transcribers for the hearing. That's not really something for the court, but it is something that we probably need to get on and book as soon as possible. And so I think my learned friend and his team just need to provide us with comments on the proposals that we've suggested to date. So with that, I was going to move on and deal with the timetable. Actually, sorry, the list of issues. I wasn't going to go through the list of issues. We've finally reached an agreement on that. So unless there's anything Your Excellency would like me to address you on, then I was just going to show you the timetable. Yeah. Now, the hope is that this is going to be done as efficiently as possible. This is an outline. This is a trial, not an arbitration. And ordinarily, the result is that with efficient case management and 2 counsel who have done this before, we will not be wasting anyone's time with our questioning, but that we will have the time that we need to get through the evidence, which is the key, really. Our proposal, my proposal anyway, is that really we ought to be getting through openings in day one, and then have a clean run at witnesses starting on the second day. I think my learned friends, and he can make his observations, but he's slightly unsure about whether he will be able to complete his submissions in half a day. I don't have a particular problem with noting that reservation. Your Excellency will be controlling all of us, no doubt, during the course of the trial. My suggestion, though, is that if we can start first thing on day 2 with the witnesses, that is immeasurably preferable, particularly because we will be then on a Friday. And if we have any witness who gets started but not finished on the Friday, then they won't be able to communicate about the case with anyone over the weekend because they'll be in Purda. And I think that's why we've put Miss Atala first, because we're largely taking our instructions from her. But it is a big disadvantage if we are unable to speak to our witnesses because they haven't finished their evidence. So I think from our point of view, it really would be a shame if we kind of overrun on one or other of those days.
My Lord, can I just briefly outline my position of why we've inserted the risk of overrun? There are, as my learned friends adverted to, some difficult issues of UA law. There are 2 clusters. Firstly, there's the nationality requirement and the profit requirement. And although those sound relatively simple in terms of saying, well, it's just an issue of whether the company and the TPA agreement are void or invalid, in fact, there's some quite tricky issues about the extent to which third parties or debtors of a company can claim the voidness of a company. There are tensions within the relevant statutory provisions in Article 16 of the Commercial Companies Law. There's an issue of de facto companies, whether essentially a de facto company arises in order to preserve the corporate status of a company. These issues, when ventilated on our application to amend the pleading to add the nullity issue, took a fair amount for Mr. Knight and me to debate before Justice Sir Richard Field, and so inevitably that will take some time. We do think it's worth dealing with those issues of UAE law first, because clearly there are going to be issues of fact around Mr. L.L.C, we would say the nominee shareholder, and the extent, the nature of his role, the nature of his entitlements, the nature of a side agreement. And if your Lordship is going to hear evidence of fact on those sorts of factual issues, then clearly it's better in our submission to have the legal issues fixed in your Lordship's mind first. So following Fidel and Felicia and following the DRC practice in terms of UA law evidence, and helped, greatly assisted hopefully by the fact that your Lordship has greater expertise on UA law matters than we do, we will attempt to canvass those issues of UA law in opening. I should just mention that the other one is obviously the issue of the probability or certainty of loss. We say that the claimant has to show on the balance of probabilities that the losses they claim are a certainty or near certainty. So we say essentially those 2 tests stack up, if you like, but it's clearly going to be important, again, in our submission, that the relevant test be fixed in your Lordship's mind before your Lordship hears the expert evidence. And we would obviously say that in circumstances where you have a claim essentially for loss of profits, and some of those are contingent profits based on contingent agreements with third parties, there are very real issues as to whether there are sufficient certainty as a matter of UA law under Article 292 of the Civil Code. So again, it will in our submission repay the benefit of some debate of the UA law issues before your Lordship hears both the factual evidence and the expert evidence. And our other point too, in terms of sort of timing of legal submissions, would be that by the time we get to closing, clearly both sides will be intent on seeking to summarise and assist your Lord, summarise the factual and expert evidence, and assist your Lordship with those bits of the evidence that have come across in cross-examination, re-examination, which may be helpful in terms of your Lordship's determinations and conclusions. So in those circumstances, we think it's helpful to canvass those issues of UA law up front, as indeed they are in the defendant's case. And for that reason, we would say that we will need at least 3 hours to do that. Now, it may well be that if there is no housekeeping, and that's sometimes optimistic, and if the claimant is done by the end of the morning, your lordship may say, well, I can give you 3 hours, and we can be done with submissions on law by and indeed opening by the end of day one. It may be, if there's been some debate and some discussion between counsel and your lordship, that we don't manage that, and that therefore there's some minor overspill, if you like, into day two. What we have committed to is that we will have finished cross-examining Miss Atullah by the end of day two. We understand her role as a primary giver of instructions, and therefore we understand that it will be important that she is available to my learned friend and his team over the weekend in terms of taking instructions. We will take a view on Mr. Saliba. It may be that he can be finished by the end of day two. It may be that he can't. It may be in that latter circumstance that it's decided that we should await Monday morning. We should start afresh with him on Monday morning. I think we really have to take that one as we go and see where we are by early Friday afternoon in day two. But as is clear, we will have dealt with Ms. Atullah by the end of day two. Sorry, my lord, that's a bit of an intermission for me. I just wanted to make clear why it is we think there may be a risk of overrun, specifically on days 1 and 2.
Can I just make a couple of observations in relation to the openings? Which is, firstly, we will do whatever is useful for you. So whatever your preference is, we'll give it to you. My understanding of openings for trials, anyway, is what is reflected in the rules, which are they're supposed to be neutral. They're supposed to be brief, and they're supposed to outline the case. They're not supposed to really argue the case in full. But clearly, if that's what you want, and if you want it in relation to discrete issues, then that's what you should get. But both parties should be forewarned of that, and we should know that. What my learned friend is suggesting is that we effectively, as I understand it, have a full-blown argument about the UAE law issues that he's identified in advance of the trial. My submission is that would be somewhat unusual. And as long as you know what the issues are, you'll have written argument from the parties, you'll have the shape of the case as you're supposed to from an opening, and then normally that sort of detailed legal argument you would expect to come at the end of the trial, and or with the benefit of written submissions later on. But if you prefer it the other way, we will do it the other way. We're very much in your hands, but we ought to know. Because what I wouldn't want to happen is that I do a very short, brief oral opening, which is neutral and doesn't descend into the argument. And then my learned friend takes 3 to 4 hours actually engaging in a deep and detailed argument about UAE law. So as long as everybody knows what the position is, then we'll do it one way or another. I think the short answer perhaps is that you just give us a time limit, and that's why we'd suggested half a day each should be sufficient. What that realistically gives is just shy of my learned friend's 3 hours, about 2 hours and 75 minutes. If we, I think, start at 10 a.m. and finish, if we're able to finish at 5 and take an hour off, and then half an hour each half an hour in total for transcription breaks, that's 2 hours and 75 minutes. So if you were to tell us you've got 2.75 hours each, use them as you like, we'll get to the end of it on day 1. And that'll be that for openings. And it just occurs to me that it might be better to have certainty about it than have parties going into it worrying about what the other person's going to do.
Well, I think, of course, we'll start at 10 and break at 1, then start again at 2 and finish by 5. This is on the first day. My concern on the second day, which is Friday, which is the official, breaking time is from 12 to 2. So on the second day, we start by 10 and we have to finish by 12. Then start again by 2 and finish by 5. Are you understanding that the time different here in day 2 for Friday?
I hadn't been aware of that, but that's good to know, and thank you for letting us know about that. I mean, I think when it comes to the witnesses, it's much less it's much less easy to predict precisely how much time that is going to take, because it does just depend on the answers you get to questions. Cross-examination is much less predictable than submission. Most advocates, if told you've got 2.5 hours, 3 hours, whatever it may be, will have a start, middle and end, and they'll be able to finish within the time they've been given. And if they can't, then it's their fault for being cut off. But if you have a witness who you're cross-examining, experienced advocates with the best will in the world sometimes just will not get in before the end of the estimate. So I think we're going to have to be flexible about the time that it'll take for witnesses. I'm hopeful that actually when we look at it, as we will do close to trial, we will realise that the real scope of the factual dispute is relatively narrow, and some witnesses may be able to be taken quite shortly indeed. And so whatever the time is that is available on Friday, we'll work around it. And I think we'll just have to keep an eye on where we have got up to in the afternoon. And if we get to, for example, 4 o'clock on Friday afternoon, and we've just finished with Ms. Atala, we might decide that it is not a good idea to start on Mr. Saliba with only an hour left before the end of the weekend. But I think we'll just have to keep that under review, Your Excellency, and to an extent, you may just have to trust us to do an efficient job with the witnesses.
Yeah. I just forget to say as well, as a policy of the court, on Friday we do online working from 2 to 4. But for the purpose for this hearing, we'll see what we can do to be there. For myself, I don't have any problem. I just want to double check with the registry as well. I think they can be online for attending the hearing, but I will be available in person if this will be agreed by the court as we discussed it at the beginning. Well, I don't have any preference, to be honest with you, about the day one. Whether just to keep it very simple, as you just mentioned, Mr. Tom, or to keep it on the UAE law, as Mr. Breed is prefer.
Well, can I just respond briefly on what my learned friend said? Clearly, in the old days, you would have a neutral opening and the claimant would spend days just literally leafing through the documents. The more modern approach tends to be that each party has a short period in which to introduce their case, deal with any specific issues that the judge or the court may have in respect of their case. And it's a fairly equal division of time. I think recognizing the fact that advocates, even in neutral openings, tend to put a certain spin on events and on the issues. And so I think the more modern tendency is that each party has a certain period of time. I would, as I've said, prefer to deal with the UA law issue by way of opening. I do think it will assist your lordship both on the nationality requirement, so that when your lordship hears factual evidence about Mr. L.L.C and side agreements, your lordship sees the context in terms of UA law, and similarly in terms of certainty when your lordship's hearing about the case, the expert case that is being made in terms of contracts that it said that GMGHS would have earned with OIC as an anchor client. I think, again, having the relevant UA law in mind would be very helpful in terms of hearing and considering that evidence. If we don't deal with it by opening, then we would be trying to essentially squeeze it into the defendant's closing. Now, the defendant's closing is essentially limited to 2 hours, possibly 2.5 hours on Friday, the 26th of May. And given how long it took to discuss the UA law issues with Justice Sir Richard Field when we sought to amend and when we ultimately were permitted to amend, that in my submission is just too short. And what we'll then end up with is further written submissions on UA law. And then to the extent that your lordship has questions on those, we might then have to have some form of reserved hearing or further adjourned hearing. And I'm sure we would all agree that that would be very unsatisfactory. So my preference would be to do it early. At that point, if your lordship has questions, it is something we may come back to in terms of oral closing, or it may be that written submissions can be prepared during trial if there are very particular issues, for example, relating to de facto to Sharqa Muhassa or to Article 16, etc. Those very sort of technical issues. But in our submission, it would be very useful to deal with that at the outset.
I see the challenge on Friday 26, so day 7 as well. We have to start at 2 and finish by 5 maximum, but the closing for the claimant will be only for 2 hours, starting by 10 and closing by finish by 12. Mr. Tom, your closing will be 2 hours only.
Well, I think,
on Friday,
I mean, I've
26.
only just been made aware of your lordship saying that there's 2 hours in the morning, 3 hours in the afternoon. I think my learned friend and I have broadly agreed we should have equal time, and we'll split it out. I think that what we've given you here in the timetable is a rough sketch of how we see it all going, and you can tighten that up as we go through. So it may be that I take, I don't know, 2.25 hours or whatever it may be, or we start a little later, or however it falls out conveniently. It's usually right that the claimant has a short reply, but I wouldn't expect it to be more than 20 minutes. But we'll have to see what happens. In terms of what precisely we're doing with our submissions, I think we can broadly leave that to each party. I think what is important is that everybody knows that there will be an equal amount of time. So I mean, if my opening is 2.5 hours and my learned friend wants to take 4 hours, I'm not quite sure what the proposal is, but I'd thought that we'd agreed that it would be equal, and anything you add on to your opening comes off your closing, but I don't know.
I think I'm saying that we would require 3 hours in terms of the UAE law, and my concern is that we have 3 hours in principle, but then we have a delayed start because there are some housekeeping issues that may have arisen over the short adjournment, and that we then have a transcriber's break, which can start at 10 minutes and often end up being 20 minutes. We do need a certain period of time to deal with the UAE law issues. As I'm very happy if the claimant wishes 3 hours in opening. I entirely respect the principle of equality of time. But that in my submission is the time that will be properly required to give the court a proper understanding of the issues of UAE law that arise.
Well, I think what I'd understood was that, and this was something my learned friend said to me previously, was that we were going to have an equal amount of time. And so if you took more time in opening, you're going to have more time in closing. So it may be that if my learned friend wants 3 hours and that leaves me with 2 hours on day 1, then I can have an extra hour in closing. But it's just a question of where we put it.
Yeah.
My own submission, Your Excellency, is advocates always ask you for more time than they really need. And if you were to confine us both to equal time in day 1, we would get it done. I mean, I've had much longer trials than this, more complicated trials than this achieve that.
On Friday, 19 and 26, can we start earlier, like 9 o'clock instead of 10? So
Yes.
then we can give the witness and the claimant closing 3 hours finish by 12. Is it possible, or?
Yes.
That's fine from my side.
But you need to double check with your witness of fact.
Oh, sorry, this is Friday the 26th. So this would be Friday the 19th.
It should be both Friday. We should start by 9, not by 10.
Yes, I'm told that's fine from my side, Your Excellency. So they'd be my witnesses, and my instructions are that a 9 a.m. start on Friday the 19th would be absolutely fine.
Then in the claimant closing, we can start at 9 as well.
Yes.
Yeah. Good. Now, for the first day, I think I a bit agree with Mr. Robert Reed about, his opening on the UAE law. So let's, bearing in mind, this is what's going to be the structure.
Very good. All right. Now, Your Excellency, you mentioned that you had some concerns about the amount of time that we were.
No. That No, that's fine now. Once after I've heard both of you today, I can understand now why we have split all of those witness in each day. So
Yes.
no more concern. Yeah, that's
Very
fine.
good.
And I don't think either of us are going to cross-examine unnecessarily. If we can deal with someone more briefly, we will do so.
And just so you know, Your Excellency, you'll see there are 2 days devoted to experts, rather than having both of the claimants' experts first and then both of the defendants' experts afterwards. What we've sought to do is split them out by reference to subject matter. So you'll have on day 4 the experts on insurance industry issues, and then on day 5 the experts on accountancy. So hopefully that will make it all make a bit more sense. And then I think we still have some overrun on day 6. Ideally, the advocates would have that time to prepare their submissions, but it is obviously critical that we get all the witnesses dealt with. So if there is any overrun, it's going to be experts, because that's where they come in the schedule, and so we've provided for that. But hopefully we'll get done by the end of day 5.
Right. Good. So I have no any other comments or question for you. So anything else we can discuss today, or that's it?
I think, unless I'm told otherwise, that is everything.
So you need to registry to get back to you as soon as possible to confirm the court availability in person or the online would be.
Yes. So in relation to this draft order, we will put in advance of paragraph 1, subject to the confirmation of the registry. Yes,
sure. And do we need to put there any timeline? I mean, 9 until 12 and 2 to 5.
Does that require confirmation from the registry, my lord? If it does, then we would ask you to seek that confirmation as part of the confirmation relating to the use of the courtroom.
Yes. Good. So any further observation or?
Nothing from me. Thank you.
Nothing from me.
Good. Thank you for both of your time. I'll ask the registry to get back to you as soon as possible.
Thank you so much.
Thank you.